And you do estate planning. How many of your clients have young kids? When I say young kids, let's just say under the age of 25. How often do you have that situation?
You know what? Actually, I'd have to say that's probably about 25% of the clientele where I meet young couples who do have minor children. And usually they've been referred to our office because of something that's happened in the family or their friend. And it triggers a thought
Caller,
process.
Lori.
So they come in and we start discussing what would be best to help protect their assets and ensure that the children are taken care of if, God forbid, something happened to both mom and dad.
Let's go to Lori. Lori, you're on News Radio, WFLA. Go ahead.
She just hung up.
So we lost Lori, but Lori, feel free to call back. Anybody out there who want to get your legal question answered, we'd love to hear from you right now. 407-916-5400. My guest today is Attorney Holly Knapik. Let's talk about what happens when you have clients, you're doing estate planning for somebody that has young kids, and let's just say under the age of 25. How would you typically handle that for them?
Typically, I will start discussing a tool, living revocable trust, and explaining why that would probably be the best option and tool to use for estate planning purposes because the
Caller,
children
Lori.
are minors and under the age of 25. We like 25 because we think by that time a child has gotten a little maturity, probably graduated from college and can handle things. But when they're under that age and something happens to both parents, what happens? Where do we go? And a trust is a tool we can use to help the parents craft that plan.
So if they've got kids that are under the age of 25 and mom and dad pass away, rather than giving that child their share outright, their share would be held in trust. Mm-hmm. It would be used to help them go to college, help them buy a house, help them buy a car, all at the trustee's discretion. And so we're really talking about holding on to that money until they've reached a maturity level where we think that they would be, or really the clients think that it'd be best for them to be able to handle it.
Absolutely.
Holly, when we do estate planning for people that have children that are under the age of 18, within the documents as well, they need to name who would be the parent to the kids.
Right. Guardian. Who would you want appoint a guardian to take care of the person and property of that minor child, minor under the age of 18? Because, again, that's a consideration that has to be made. And usually I always say, your toughest decision here is who is going to be in charge of the trust, the money, and managing it. And then who would you want to take care of your children if you're both not here?
Yeah, that's a hard one. Mm-hmm. Often they'll say something like, well, I want my sister to be the guardian of my kids. And then my question to them is, okay, is your sister married? Right. Yeah, she's married to Mike. Well, okay, if your sister died, would the kids stay with Mike or would the kids move on to your choice number two?
Mm-hmm.
Yeah. And depending on what they say, it changes the language that we put within the guardianship provision.
Exactly.
Minute.
Yes.
Yeah, so and then there's one other thing, and that is, okay, we put the sister's name first, and it says if they get divorced, then we also have language that says the kids are going to go with the person name first. Not Mike in that situation. So that is a tough question for people. If they mom and dad pass away, who's going to be the parent to their kids that are under the age of 18? That is a tough choice for most people.